All right, good afternoon. I apologize for the delay. Criminal calendar from 8:30 just concluded. I'm going to call the oral argument motions calendar first for announcements. Christine versus Larry Dunlap versus Progressive Mountain Insurance. It's plaintiff's motion to compel.
Yes, good afternoon, Your Honor. James Palmer on behalf of Ms. Lampkin.
Jamil Irvin on behalf of Mr. Dunlap.
And Catherine Rouse on behalf of Progressive.
Catherine Rouse for Progressive. Okay, I didn't have your name here. And Mr. Palmer for the plaintiff. All right, Mr. Palmer, how long will your motion? And is this all that we're arguing today? Is this motion to compel?
Yes, Your Honor, that's it. And I think my side will take less than 10 minutes.
Okay. All right, Mr. Irvin. Who is opposing it? Mr. Irvin, the defense is opposing the motion?
Yes, Sean.
Okay. And Ms. Rouse, will you have any argument, or are you just here to observe?
I'm just here to observe, Your Honor.
Oh, all right, I'll be with you all in just a moment. Position 2, Jamie Beard versus Gas Express LLC, Honor LLC, 5883 Food Mart LLC. This is the defendant's motion to compel discovery. I think that's what it says on my calendar. Is anyone here from Gas Express? Ms. Stokes, can you confirm that this motion was not taken off the calendar?
Yes, I'm going to right now.
All right. All right, I'll call the civil non-jury calendar for announcements. Position 1, American Express versus Larcell Bennings and Larcell Enterprises.
Judge Daniel Green for the plaintiff. I have an announcement in that this case was already adjudicated. We had a hearing and the defendant's attorney consented to a judgment on the pleadings being issued. So I'm not sure why this case is still on the calendar.
Me neither.
Your Honor, I don't know. I don't know that no order, I don't believe, has ever been submitted to the court. But
That
if
probably
I could have if I could have Mr. Green contact me, I'd like to discuss with him a resolution of the case.
That's fine, Judge. Well, what I would still propose, since it's already been adjudicated, is we'll submit a proposed order to the court and we could still reach out and try and settle the case outside of the judgment, Your Honor.
That's probably why I moved it to another calendar, because I never got an order.
Okay, I'll make sure that you get an order, Judge. Do you want us to send that to Ms. Stokes?
I don't even see that a motion for judgment on the pleadings was filed.
It wasn't filed, Judge. It was I orally moved for judgment on the pleadings at the last hearing because Mr. Store's client doesn't dispute the debt. And it was granted at the last hearing. I didn't realize that our office didn't send a proposed order in. So do you want me to send that to Mrs. Stokes?
Yes.
Okay, we'll get that done immediately.
Okay. Otherwise, we'll send out another notice and put you on another calendar.
I understand. Thank you,
All right.
Judge.
Thank you, Your Honor.
You all are excused, I guess, unless you have
Thank you.
something else.
No, ma'am. Thank you.
Thanks. All right, second position, Pennsylvania State Employees, nice cutoff, versus Kajo Logan. Oh, sorry, that's been dismissed. I should read my own notes that people leave me. Position 3, Capital One versus Israel Smythe. Ms. Stokes, I see that they filed a motion for summary judgment after this hearing was scheduled. So I don't know why no one is here though, because I didn't excuse anyone, I don't think.
Yes, they did just file that. I seen that earlier today. I thought they were still cooking. You know, you
Okay. Whoever filed that motion, like, can you figure out who that is and tell them that they're not excused? I didn't excuse them, did I?
so,
Yeah. Otherwise, it's gonna be dismissed.
okay.
All right. I don't know why the defense is not here either. All right. So, Mr. Palmer, are you ready to proceed on your motion?
Yes, ma'am. Yes, Judge.
Do you need takedown by the court reporter?
No, ma'am, I do not.
Does Mr. Irving, would you like the matter taken down by the court reporter?
No, Your Honor.
Ms. Rouse?
No, Your Honor.
All right. And since I guess nobody else has bothered to appear who's still scheduled, I'm going to release the court reporter at this time. Ms. Holloway, you're excused. Thank you. All right. You have the floor, Mr. Palmer.
Thank you, Judge. And I think background in this case is important. This case involves a car collision where the BI, the liability carrier, has already tendered the limits of its policy. Nevertheless, UM and the liability, the counselors for both of them are obligated to participate in discovery. As you know, Judge, the UM carrier steps into the shoes of the defendant after after the liability policy's already been tendered. Getting into the need for the motion to compel the defendant's deposition has been scheduled and properly noticed 3 times, Your Honor, and all 3 times the defendant has been a no-show. That's what led to the need for filing a motion to compel, and under the OCGA 91137, a party who failed to obey discovery orders or engage in delay tactics should be sanctioned, and that's the motion and basis that's the basis for our motion here today, Your Honor. We're asking the court to grant our motion to compel in full and award attorney's fees and expenses, and we want to send a strong message that the tactics and delay will not be tolerated, especially when it's been noticed 3 times, Your Honor. It's not like this is the first missed deposition. It's been talked about, discussed, and scheduled 3 times over, and it's just causing a serious delay in getting this case either put on a trial calendar or pushed to final resolution.
Okay. Mr. Irvin?
Yes, Your Honor. Plaintiff's counsel is correct. The deposition has been scheduled 3 times. I had some difficulty locating my client and securing my client's attendance at the deposition. Each time that it was scheduled, I had talked and spoke with my client and confirmed that he would be there, and then found out prior to the deposition that he wouldn't be. Like the first time, I think we rescheduled it twice, and the second time, and I believe the third and final time at the deposition, we just went ahead with it, and I think we received a certificate of non-appearance. So we did try to inform or reschedule the depositions. And as plaintiff's counsel has stated, this case is now settled. Back in May, we tendered our limits, and we have at this point again secured our client and set a new date for the deposition for July the 18th, as my client is available on most Fridays, and we've been trying to do that for a couple of weeks and just set a date for that deposition for July the 18th. And he is planning to be there. Spoke with him as early as yesterday. He's aware of it and is planning to be there since there's no issues with this court. And I believe that, quite frankly, I believe that the motion to compel is somewhat, well, not somewhat, is moot, considering that we tendered limits and that we have a new date scheduled, and he's planning to appear. And also, I thought that considering the order that was filed, there was no 6.4 certificate, so I thought the motion was premature as well for sanctions. I would also like to know that we offered, after the first deposition was rescheduled, I did go ahead and amend the complaint and admit to liability. So understanding that, obviously plaintiff's counsel has the right to, depose my client, but just, because my client didn't show up, I just amended the answer and we, admitted to liability. And so, plaintiff's testimony, defendant's testimony, would only, you can't talk about damages. So it would be, the focus would be on liability, but that's my position. I don't believe that sanctions are warranted at this time. And I would oppose the granting of sanctions.
All right, Mr. Palmer, final word.
Yes, Your Honor, there was no response to our motion filed. The 6.4 correspondence was sent to both defense and UM in this one. And I have sympathy for Mr. Urban because I know that he was trying to get his client to show up, but the bottom line is his client hasn't shown up. It's been rescheduled 3 times. This will be the 4th. I'm not confident that the client will show up. There is additional coverage through UM on this one. I think UM has an obligation to make sure that the defendant shows up for their deposition, as they would be stepping in and defending should this case wind up in front of a jury in your courtroom, Your Honor. So I think sanctions are warranted because we've really pushed for this. And this case is an old case, Your Honor. This one's been pending for a while now. So that's our position.
Was the 6.4 certificate filed in this matter?
I don't think the certificate was filed, but the 6.4 correspondence was sent, Your Honor.
How do I know that? What is the usual mechanism for letting the court know that?
I'm guessing filing the certificate, Your Honor.
I think so. What are you asking? You're asking for attorney fees for the missed depositions and what else?
Fees and sanctions, any appropriate other sanctions, Your Honor.
And what are you asking for?
$1,000 in fees, Your Honor.
Did you submit any documentation to your motion?
To support the fees?
Yes.
No, Your Honor.
I'm gonna hold off on submitting the order in this case until after July 18th. So I'll prepare an order what I anticipate I will rule, but I need somebody to get back to my office and let me know if there's an actual what happens at this deposition, if he's going to be a no-show again or what. I've had the situation happen before in the past. When this happened, I have no problem striking the answer and it just have a hearing on damages. I just don't like time to be wasted. And so I understand that I don't know if the defendant understands the significance of, the UM still being in the case or whether or not he cares. I don't know. But, and again, I'm not making a decision to whether any sanctions would be issued at this point because I need to determine whether the proper procedure has been filed by the plaintiff in asking for these sanctions. So, just let us know what happens on July the 18th. And we'll probably enter order on whatever that following Monday is, the following week after the 18th.
Thank you, Judge. I appreciate it.
Thank you, Your Honor.
Anything else? All
Nothing.
right. Thank you. Y'all are excused.
Thank you.
Thank you, Your Honor.
Thank you.
This
Hey, Judge, okay. He is, let me see. No. Yeah, because she, so yeah, you can get on. Okay. What's the email? Mhm. I'm gonna send it right over to you, and then, yeah, we just see. Just hop on. Okay, okay, of course. Mhm. Oh, it is, I got off.
Just wanted to let you know I am on the call, Your Honor.
Hello.
Hello, I apologize, Your Honor. I apparently didn't receive the calendar, but I certainly would not have ignored it if I was aware of it, so I apologize.
Well, this is the defendant's motion. You represent the plaintiff, right?
Correct.
Okay. Miss Stokes, did we have any contact reaching and I'm not sure which defendant this was. I'm assuming it was Gas Express.
That I think so. They had filed. Well, there were two motions that were filed. One was Anur LLC had
Yeah.
filed a pro se motion that we had responded to.
Yeah, I can't schedule that one though, because that's not proper.
Right. The other one, the defendant did file a motion to compel our responses to discovery, which I actually thought it was filed on the 11th. I thought I had additional time to respond to that motion, but I don't intend to oppose the motion. I'm trying to get the responses together and get them to them as soon as possible. So if they're not on the call, I think it was there looking at the calendar notice now that I was able to pull it up. I think that was the motion that was on, and I don't, I think they are entitled to their responses, and I apologize for the delay, and I can get them to them within the next 7 days.
I don't know if they got notice of this. And you did not get notice, is that right?
That's correct.
Yeah, something went wrong. I don't see where notice was sent out.
Okay.
So I had just transitioned to a new assistant, and this may have been one of those cases that kind of fell in the cracks or something, because as I'm looking on here now in the docket, I don't see where notices were sent out. So that would explain why you didn't know to be here.
Right. Or the defendant.
Unless, was anything else go on here? Like, let me check one more other place. Well, what I'll do, I don't know why this is on this calendar. I don't, because I don't see where they asked for a hearing unless I
Right.
wanted to have it on the calendar to explain some things to the pro se litigants. But anyway, I'm just going to rule on the brief, and
Okay.
we'll go from there.
I think we do still have some time under the rules I think the motion was filed on the 10th, so we would have
Yeah, it's not even right. I don't know.
Right.
This.
So I would like time to file a
That's
response.
correct.
And my
You do
intent,
have time.
right. And my intention is to get them the responses, which will hopefully make the motion moot.
Yeah, I think we may have just put this on the wrong calendar. So our apologies to you, sir.
No, I'm sorry, Your Honor. I didn't want you to think I was ignoring the court order.
This is completely on us, and I apologize for that. And you have a good rest of your day.
Thank you. You too, Your Honor.